This conference will now be recorded.
Hi everyone, my name is Yasir and I'm your tutor for contract law. As we discussed contract law yesterday's, and today we will discuss about learning outcomes one. Uh, a promise contract law. We will discuss about understanding the rules that govern the contract content of contract. So we will also use the key terminology. Promise as a truth of terms, a promise as the truth of statement, uh, a statement written or oral made during the negotiations leading to a contract may be a term of the contract or merely a representation include the contract. Also, there is another terminology which is called representations. Uh, there is no promise, but the statement induces the making of the contract. So basically, representation is something that is sent by the offer in order to induce the offeree to enter into the contract. It may or may not become a term of that contract. The difference between terms and representations is important because if a statement is untrue, the remedies available to the innocent parties and uh, available to the innocent parties differ. So the next thing is compare and contrast terms and representations. A statement made during the course of negotiation uh, a good amount of a contractual terms or a representation. It is important to know whether a particular statement is contractual terms or if it is a representation, as this will determine the appropriate cause of action and remedies available. So, uh, uh, if the statement amount of a term of the contract which is not fulfilled, the innocent party may sue for breach of contract. If the statement is merely a representation which turns out to be untrue, the innocent party may bring an action or misrepresentation. So basically, uh, he is that if the statement amount to a contract terms that is not met, the innocent party, he says, may file a lawsuit for a breach of contract. So if the statement is only a representation that turns out to be false, the victim may file a misrepresentations claim. So another thing is, if you look at page 4, it says a misrepresentation is a false statement of fact or lawsuit which induces the representee to enter a contract, where a statement made during the course of negotiation is classed as a representation rather than a term or action for misrepresentation may be available where the statement turns out to be untrue. There are three type of misrepresentations basically. The number one is innocent misrepresentation, and number two is negligent misrepresentations, and the finally are fraudulent misrepresentations. The effect of a finding of a misrepresentation is the contract is avoidable. Uh, for example, the contract exists but may be set aside by the representee. The remedy available depends the type of misrepresentations, but generally consist of recession and damages. The right to re-sign the contract may be lost in some circumstances. Uh, the law relating misrepresentation is mainly found in common law with the Misrepresentations Act 1967, providing some further details. So if a statement made during negotiation is classified as a representation or as opposed to a term, a claim for misrepresentation may be applicable if the statement turns to be false. So depending on the nature of misrepresentation, the potential preparation may consist of damage. So there are source of terms. So here, uh, page 5, if you look at the source of terms are summarized in the following diagram. It says that source of terms, there are basically two, source of terms which are primary source of terms. So express and implied. So express and implied. So express terms are those that are expressly agreed to by the contracting parties, while implied terms are those that are not expressly agreed to by contracting parties but are implied into the contract by the courts or the legislature. So also express terms may be agreed to orally or in writing. So these may be implied for three sources. Uh, uh, there may be implied from three sources. There are also implied terms which are comes from three sources. Statute These statutory implied terms are based on the rules of law or public policy. These may be implied from three sources. So number one is that by court. Okay, uh, a contract may be interpreted to you know embody any relevant code of the market, trade, location where it is formed, provided the customer in that consistent with the specific terms of the contract or its nature. So another thing is terms of contract set out duties of party under the agreement. The terms will be of two kind: express terms, which are already that explain that are and then implied terms that are read into the contract by the court on the basis of the nature of the agreement and the parties. So apparent intentions or on the basis of law, on certain type of contract. So generally the terms of contract may be either wholly oral, I mean that completely oral law, or oral, your contract can be oral and wholly written, or partially oral and partially written. Uh, Terms are to be distinguished from statement made prior to the contract being made. So two main type of statements: representation about a statement of fears, or promise that something will or will not occur in the future, which can that depend on circumstances basically. So either type of statement can become a term of the contract, whether or not they are oral or written, or partially or oral or partially written. So here is the oral statements. So oral, the key issue is whether oral statement made during negotiation prior to conclusion of contract become a term of the contract, or remains mere representations promise. This is a question of fact. Courts look at wide range of factors. So the basic question is, the central question is, or main question is, whether an oral statement made during contract negotiation prior to its conclusion become a terms of the contract, or remains a simple representation promise. So timing of statement, generally the more time between statement and conclusion of contract, the less likely is statement to be held a term of contract. Uh, See, for example, that he's talking about one of the case law, Routledge versus Mackay, and 1954 timing factor is point of departure only if statement is otherwise strong and important, then they may override significant delay between when it was made and when contract made. For example, he's talking about another, case law, which is shovel entry, or we might be discussed later on this chapter. But also, if you want to see any case laws, you can see, as I did not mention yesterday, but I think so. It's a Westlaw. Yeah, it's a Westlaw and library. You can go online and you can check, and also it's Lexis. You can check there as well. There are few, uh, uh, it's not a fully. You can look at every single one, but few are free. That source is available there, and you can check. Express terms, oral statement, count, uh, the strength of statement, the more emphatic the statement is, the more likely to be viewed as a term. See shovel and redo above, as again talking about, ATHE Godfrey 1947 is a case law. And then special knowledge and skills of parties. If statement made by party with special knowledge and expertise on matter, courts more likely to deem statement a term than if statement made by someone without such expertise. For example, again, one of the case law, which is Dick Bentley Production versus Harold Smith Motors Limited 1965. Uh, Then Oscar Chess versus William 1955, Nation of Collateral Warranty, see Paul, page 208 to 09. So, as I said, if you want to see any case laws regarding, related to contract law, or you can go to Westlaw Library or Lexis. You can check where are, resources available, or for further, if you do want to know, then just contact me, or I can give you a links, or so on. There is an express term, oral statement, uh, then. Uh, It contract is put down in writing. Any statement operating in that written agreement will usually be regarded as a term, and any prior oral statement that is not repeated in the written agreement will usually be regarded as a representation due to assumptions. So that if a statement is left out of a written agreement, the parties did not view the statement as important. So again, he's talking about Routledge versus Mackay, and also Duffy versus Orse versus Newcastle United Football Company. That is a case law. A signature will usually make it difficult for the signatory to successfully argue that the written terms of the agreement do not represent what they have agreed. So again, you can look at Estrange versus Grocop Limited 1934 is a case law. So now express terms, oral contract, incorporation of written terms. So the question is asking, when may written text to be regarded as a forming part of terms of an otherwise oral contract. So incorporation must occur before contract is concluded. For example, again, he's talking about a case law, Chaplain versus Barry Urban District Council, 1940. Incorporation can, you know, take place on basis of signatures, responsible notices. Generally speaking, it is harder to show incorporation. The more onerous or unusual it is written clause, For example, Thornton versus Shoe Lane Parking Limited, 1971. In assessing the extent to which clause is onerous, the unusual, one focuses on meaning and effect of the clause is questioned, not the kind of type clause. Ocean Chemical Transport versus Exor Credge Limited. See further. So uh, we might look at few case laws in next couple of slides. But before that express terms is in talking about in detail that interpretation of express term. So interpretation of express term basically when construing meaning of contractual terms, courts attempt to ascertain the intention of parties on an objective basis. In Investors Compensation Scheme Limited versus West Bromwich Building Society, 1988, Lord Hoffman stated that courts must look for the meaning which the document would convey to a responsible person having all the background knowledge which would reasonably have been available to the parties in a situation in which they were at the time of the contract. So there is another thing is ongoing debate about the extent to which background knowledge, often termed factual matrix, is to be made taken into account. Traditionally, courts have been reluctant to take account of background material. So basically, when a contract is, that contract courts use an objective standard to, determine the party's intent when interpreting the meaning of, contractual term. So then payroll evidence rule. So is talking about when a contract is reduced to writing, neither party uh, can submit evidence extrinsic to falling outside the contractual document, alleging terms agreed upon but not contained in the documents. For example, of rule in practice, Henderson versus Author case law is talking about this situation. So many exceptions to rule, for example, intention that the above point basically it says that when a contract is reduced to writing that were agreed upon but not including in the documents. So intention that agreed to only partially written if written document was not intended to set out all the terms agreed between the parties. Extrinsic evidence of other terms in admissible. There is a tendency nowadays for court to infer if possible such an intention. Also rectification, that rectification, I mean that if there is any you know not accuracy or mistakes, or there is some loopholes or things you might be can change, or if the document is intended to record previous oral agreement but does not so accurately, evidence of oral agreement is admissible. Then payroll evidence rule, exceptions for proof of custom or trade usage. Evidence may be admitted to prove a custom or trade usage that would cost light as how a terms in the contract would be construed. See, like he's talking about a case law Smith versus Wilson, and clarify ambiguity, extrinsic evidence admissible to clarify ambiguity in express term. So show capacity of parties, extrinsic evidence admissible to show in what capacity the parties were acting when they entered agreement, for example, as principal of agent. Uh, then show how contract operate, payroll evidence uh, admissible to support or rebut any terms implied by law. So collateral contract. So if basically the collateral contracts means that if one party states that he will sign the contract written agreement only if he is assured that it will be interpreted in a particular manner. So oral statement can be deemed binding even when it is not a term of written contract. It if it gives rise to collateral contract if one party says that he will sign the written agreement if he is assured that it is to be uh, constituted is a certain way. Two contracts may arise the written agreement and a collateral contract based on the oral statement. A classic exposition is the judgment of Lord Moulton in Halbert Simons and Company versus Bucklanton, which is talking about oral statement and written judgment agreement. So good example of device is Operating City and Westminster Properties Limited versus Mudd 1959. So device of collateral contract is a way of avoiding payroll evidence rule. So it says that collateral contract is a way of avoiding payroll evidence rule. So, but device requires provision of consideration, which will usually be entry into main contract. So, remember rules on past consideration. Express terms number 9, entire agreement clauses. So, these clauses state that the written contract contains the entire agreement. So they are aimed to preventing one party subsequently claiming then an earlier statement is also part of the written agreement. These will be upheld by the court but do not exclude liability for misrepresentations. So significance of wording when possible words are to be given their natural and ordinary meaning. This may be departed from where the word would lead to absurdity or inconsistency with the rest of contract. For example, Sinochem International Oil London Limited versus Mobile Sales and Supply 2000 per Court of Appeal. So basically, they are intending to prevent a party from later asserting that a previous remark is also a part of the written agreement. Uh, these will be supported by the court, but do not eliminate responsibility for misrepresentation. He is uh, basically talking about entire agreement clauses and significance of wording. So next is implied terms. So the categories of implied terms are implied by fact, implied by law, by custom, by trade usage. So terms implied by fact. So these are terms that court assume both parties uh, would have intended to include in the contract had they uh, thought about the issues. They are implied on a one-off basis. Then two overlapping tests have been tried used to ascertain parties' intention. So here is obvious bystander test if while the parties were making the bargain a obvious bystander were to suggest some express provision for it in the agreement, they would testily suppress him with a common O of Corsel, Sherlaw versus Southern Foundries, 1926 per Macklin, and then business efficiency test. Terms must be employed to make contract work. Leading case is the Moorcock, 1890, 1889, which we will discuss further. Uh, After a couple of slides, you can see that the Moorcock 1819. So later case law, Trollope and Coles Limited versus Northwest Regional Hospital Board, 1973, makes clear that terms only implied if contract cannot work without it. So no sufficient that terms makes contract failure or more sensible. So terms implied by fact count, both tests are subjective in the sense that they ask what parties in the case of in the case at handle would have agreed, and not what a reasonable person in their position would have agreed. So the terms cannot be implied if one of the parties was unaware of the subject matter of the terms of facts and which it is based. For example, Spring versus National Amalgamated Steve Dawes and Dockers Society. Now, however, application of the two tests has been supplanted by an objective construction approach stipulated by Privy Council in Attorney General of Belize versus Belize Telecom Limited, 2019, 2009. It says that this approach involves arriving at a proper construction or interpretation of the contract. Uh, in every case in which it said that same provision ought to be implied in an instrument, the question for the court is whether such a provision would spell out in express words what the instrument read against the relevant background would reasonably be understood to mean. Peer Lord Hoffman. So implied term in law, these are terms which the law requires present in certain type of contracts. So basically, it's the terms implied by law that law requires to be included in certain sorts of contracts. Employment contracts will include implied terms that the employer will provide a job reference to departing employee. So basically, certain type of contracts mean one just on one-off basis and sometimes irrespective of the wishes of the parties. For example, tenancy agreement will include implied terms that the landlord must take reasonable care of keep common parts of property and in good repair, like Liverpool City Council versus Irvine 1977. Contracts of employment will include implied terms that employer will give departing employees a job reference. Uh, Spring versus Guardian Assurance PLC 1994, and implied terms that employer and employee will not act in ways so likely to undermine the trust and confidence required if the employment relationship is to continue. Malik versus Bank of Credit and Commerce International SA 1997. Again, he's talking about case laws. So, as I said earlier, guys, case laws are very important. As much as examples you can, or you can mention case laws, that would be a good impression for, examiner, or you can learn more, about laws, law practically, if how law apply practically. So again, if you look at Westlaw, you can see lots of case laws. So statutes will also imply terms sales of good, and consumer will have implied terms that good are of satisfactory quality. Uh, if you see Sales of Good Acts 1979 and Unfair Contract Terms Act 1977. So terms implied by custom, terms can be implied if there is a evidence that under local custom they would usually be represent. See, uh, for example, see, sorry guys, terms can be used to contract within a particular trade or business, may be implied into other such contracts. See, for example, British Crane Hire Corp Limited versus uh, Ipswich Plant Hire Limited, 1975. So, identify the source of contractual terms. Another thing is terms may be express or implied. Express terms are those specifically inserted into the contract by one or both of the parties. They must be clear for them to be enforceable. Scammell versus Austin facts. There was a facts, an agreement provided for the balance of the price to be paid on hire purchase terms over a period of 2 years. Held the words hire purchase terms were considered too imprecise as the seller had a range of such terms. So implied terms are not expressly included in the contract, but they are nevertheless still part of the contract. They may be implied by statute or by the court, or rarely by custom. An example of this is a contract of employment which has implied terms such as an employee duty to obey lawful and reasonable orders. Uh, we will see in chapter 4. Uh, Express terms will generally override implied terms. However, some statutory terms cannot be overriding by express agreement. For example, terms inserted by the Sale of Good Act 1979. So here another thing is contractual terms in English law is a topic which deals with the main four main issues. Okay, or the terms of contract represent its core and inform the reader of the contract's purpose. So, which terms are incorporated into the contract? How are the terms of the contracts to be interpreted? Whether terms are implied into the contract, or what contracts uh, are placed on unfair terms. So, Morcock case we discussed earlier, and here is it was a case law in 1889. So there was an agreement by a wharf owner of a permit ship owner to unload uh, unload his ship at the wharf. The ship was damaged when at low tide, so it was grounded on the bottom of the river on a hard ridge. So the court implied a term into the agreement that the river bottom would be reasonably safe for ship to dry out on. So what was the type of terms in Morocco case? There are three type of terms: conditions, warranties, incombinate terms. So the distinction between the type of term is important because it determines the remedies they may available in the event of a breach. So here he is discussing about difference between condition, warranties, and incombinate terms. So what is the conditions? So conditions, there are the more important terms of contract, the most important terms of the contracts. So simply, if I explain you the conditions, most significant contract clauses, serious effective breach. So the innocent party may regard, I will explain you in my words before I go there. So the innocent party regards the contract as a rejected or sue for damage. A condition in contract is not always determinative of whether the term is a condition. A breach may result in damage, dismissal, or maybe both, or discharge allows the innocent party to renounce the contract and seek compensation. So here he's talking about a case loss we discussed earlier. He mentioned earlier Sushler AG versus Wickman Machine Tools Sales Limited 1974, and also he's talking about sales of Act 1979. Then discuss are to be treated as such. For example, the Michaelis Anglos 1977 Court of Appeal expected readiness clauses in charter parties are usually to be regarded as conditions. So condition is important term going to the root of the contract. So it's a very important for root of the uh, contract. So another thing, the next thing, warranties of lesser important than conditions and can be breached uh, without such serious consequences. Innocent party can sue for damage but is not able to terminate the contract. So a warranty is a less important term which is incidental to the main purpose of the contract. Breach of warranty result is damage only. So there is a case law between Bettini versus Guy. So basically it says that warranties are of lower value than terms and may be violated without as severe effect or results. So the innocent party may be claimed for damage, but they can't cancel the contract. So next is innominate terms. Innominate terms can be either condition versus or warranties. Breach of them can be serious or uh, trivial depending on a particular fact situation. If a fact serious, they are conditions and vice versa. Notion of such terms first emerged in Hong Kong. Fair Shipping Company Limited versus Kawasaki Limited 1962. And innominate or indeterminate terms is neither a condition nor a warranty. The remedy depending on the effects of the breach. If a trivial damage only, for example, terms is treated as uh, if it were a warranty. If serious damage, discharge, both terms treated as it were a condition. So basically, in nominate terminology, depending on the specifics of the case, violation may be severe or may be minor in both sides. So here is the case laws. Hansanord case is talking about. So if you look at facts, so uh, citrus pulp pallets for used animal food had been sold for £100,000 under a contract which provided for shipment to be made in good condition. Part of the goods had not been so shipped, and in addition, the market value in such goods had fallen at the delivery date. The buyers rejected the goods, which were later uh, resold pursuant to court order and eventually required by the original buyers, or just under £34,000. The buyer then used the good for the originally intended purpose of making cattle food. So what was the held? The Court of Appeal held the rejection was not justified. The terms as to shipment is good condition was neither a condition nor a warranty, but an innominate term, and there was no finding that the effect of breach was sufficiently seriously justify rejection. So the buyer seems to have tried to reject not because the goods were impaired, but because they saw an opportunity and acquiring them at well below the originally agreed price. So in these circumstances, their only remedy was in damage, so they were entitled to different to the difference in the value between damage and sound goods. So uh, here is a, however, Hong Kong fair approach is far from Dead Sea, Torvald, Clavinets, uh, as versus Orny Maritime Corporation, the Gregis 1994. It may even apply in cases involving contracts for sale of goods. For example, on a Sihave versus Bremer, the Hansa Nord 1975. Poole argues that instead of operating with three classes of terms, one should just operate with the two classes, conditions and non-condition. So next is analyze the interpretation. Uh, so next is interpretation. So uh, basically, in nominate terms, which if in short, if I tell you, that it may even be applicable in circumstances involving sales contracts. So Poole believes that instead of using three categories of terms, just two should be used, which are conditions and non-conditions. So next is analyze the court approach to interpretation and validity of exemption clauses. So an exclusion clause or exemptions clause is a term that seek to exclude or limited party liability or breach of contract. So common law rules, in order to be valid, an exclusion clause must satisfy two conditions. One is it must be incorporated into the contract, and its wording must cover the loss. An exclusion clause can be incorporated into a contract by signature, notice, or previous dealing. So, signature, the case of Estrange versus Grossup. Grockhub 1934 established that a clause is incorporated by signature even if the signatory did not read or understand the documents. But however, the situation in above case can be contrasted with the Curtis versus Chemical Cleaning 1951, in which it was held that a signature does not incorporate the clause if the effect of the terms was misrepresented. So Curtis versus chemical cleaning liability for damage to a wedding dress was not excluded due to misrepresentation of the clause. Next is notice for an exclusion clause. To be incorporated by notice, reasonable step must have been taken to bring it to the attention of the other party at the time the contract was made. What are reasonable steps depending on the circumstances, which is talking about in Thompson versus LMS Railways 1930 case laws. So also is talking about a case law which is Ole versus Marlborough Court 1949. A clause can be incorporated by notice providing it was given before making the contract. So a notice in hotel room did not exclude liability as the contract was made as the reception desk. So here is another case law, Superling versus Bradshaw. Clause to be incorporated by previous dealing, there must have been a consistent course of dealing between the parties. So he's talking about fact the defendant had been dealt with the claimant for a number of years on the contract in question. He delivered four full barrels for storage as usage. He later received a document which acknowledged receipt and contained a clause excluding liability for negligence. When he came to collect the barrels, he found they were empty. So the exclusion clause had been incorporated into the contract, even though it was received after the contract was made. It had been incorporated through the previous course of dealing, whereby he had been sent copies of documents containing the clause, even though he had never read them. However, Sperling versus Bradshaw 1950 can be contracted with Hollier versus Rambler Motors 1972, in which three or four deals between a garage and a private customer over a 5 years period were held to be insufficient to constitute a course of dealing. So the wording must cover the loss under the contra proferentum rules. The court interpret the word narrowly against the interest of the person seeking rely on the clauses. So uh, he's talking about another case law, which is Photo Production Limited versus Securicore 1980. The fact was security guard burned down factory he was guarding. The contract between his employer and the factory owners limited employer's liability for injuries act and default of guards. The clause was clear and unambitious, ambiguous, not effectively limited their liability even for his fundamentals breach. So there are some statutory rule. Even if clause passes the common law test, it must be a satisfy the statutory rule. There are contained in UCT Act, 1978 and UTCCR Act 1999. So UCT Act, Unfair Contract Terms Act, which is 1978, applies to example clauses in contracts made in the course of business. In states that a clause exempting liability for death or personal injury due to negligence is void. Other loss due to negligence is void unless reasonable. Where there is any standard from contract which could be between two businesses or any contract between a business and a consumer, any attempt by a business or exclude or restrict liabilities for breach depends on whether the clause is reasonable. The burden of providing reasonableness is on the party seeking to rely on the clause in assessing whether or terms in is unfair or unreasonable. The court has regard to the strength of the bargaining position of the parties, whether the buyer received an inducement to agree to the terms, whether the buyer knew or ought to have known the existence and extent of the terms, the ability of party to insure against the liabilities. So his Alban City and District Council versus International Computers Limited case. The fact was the defendant had been hired to produce a computer system which would calculate population figures on which the claimants would restricting liability to £100,000. The database that the computer system produced was seriously inaccurate, and as a result, the claimant sustained a loss of 1.3 million. So the clause was unreasonable. The defendant could not justify the limitation of £100,000, which was small both in relation to the potential risk and the actual loss. So, in addition, the defendants had insurance of 50 million pound themselves. So there was there. So therefore, it was reasonable to expect that those who stood to make the profit and had been well able to insure and had insured should carry the risk. So the next was UTCCR, which is unfair terms in consumer contract regulation. So above, uh, he was discussing about unfair contract terms act, and so now he's talking about unfair terms in consumer contract regulation. So applies 1990 applies to contract where the seller is acting in the course of business, the other party is a consumer, and the terms have not been individually negotiated. The regulations apply to all terms of contract, not just exclusion clauses in terms is unfair if it is not expressed in plain, intelligible language, uh, contrary to the requirement of a good faith. It causes a significant imbalance in the parties' right and obligations, and this is to the detriment of the consumer. A term is unfair if it allows the seller to alter the terms of the contract unilaterally without a valid reason which is specified in the contract. Shield 3 UTCCR 1999. In a term is unfair, it is not binding on the consumer, though the rest of the contract can stand. So, right, this is the end of the guys uh, today's lesson. Uh, so you can see that if you look at summaries, does the clause passes the common law rules? Uh, uh, Above clause, it is incorporated into the contract. Does the wording cover the laws? If no, the clause is void. If yes, consider statutory rules. So in UCTA in 1977, if the contract is made in the course of business, UCTCA 1977 will apply. So if the party is a consumer and the other is business, so UTCCR 1999 applies in addition to you know UCTA 1977. So contract will be void if example exempts liability for death or personal injury, other loss void unless reasonable. So it's unfair and not binding if not expressed in plain language or it causes the imbalance in party rights. So that's it. This was the today's lecture. Or if you have any questions or want to ask anything, please drop me an email tutor dash management ukversity at ukversity.co.uk tutor slash management, dash management at ukversity dot uk dot co dot uk. Thank you very much, guys. Have a lovely evening and good weekend. Bye.